speaking to Patrick Amimo in a couple of minutes. Allow me now to cross over to the Supreme Court, where judges are hearing a petition by Kenya National Commission on Human Rights, which is seeking clarification on a clear standard to measure integrity and leadership of aspirants seeking public office ahead of the polls. The commission is seeking a determination on how the Constitution in Chapter 6 should be applied as a fit and proper test for all leaders seeking appointive or elective posts. Let's now bring in our Murimi Mwangi, who's at the Supreme Court. Murimi, good to see you. Good morning. Looking at this particular case, there are those who say it may potentially lock out several aspirants looking at Chapter 6 of the integrity, Chapter 6 of the Constitution, looking at the integrity, the leadership and integrity clause. What are you hearing on the ground?
Good morning, Linda. That particular petition has already been presented before the deputy registrars of the Supreme Court, and they have given directions that the hearing will appear before the full bench of the Supreme Court on the 21st of June. But most importantly is that the Kenya National Commission on Human Rights has petitioned the office of the Attorney General, the Kenyan electoral body IEBC, as well as 12 political parties, including the key political outfits in this country, the Jubilee Party, ODM, Wiper, Ford Kenya, and Wiper, which essentially form the major opposition outfit, NASA, as well as the ruling Jubilee Party. But of course, besides that particular issue, the Human Rights Commission is seeking an advisory opinion from the Supreme Court on just how that implementation of the provisions of Chapter 6 should be undertaken. Remember, the very first time we had such a petition before the courts was in 2013 when President Uhuru Kenyatta and his now Deputy William Ruto were facing crimes against humanity charges at the ICC. And at the time, petitioners had moved to court to seek if they were qualified to run for office on the basis of provisions of Chapter 6, as well as the Ethics and Leadership Act, as well as the Political Parties Act at the time. And of course, that time there was a position from the courts that there had to be that presumption of innocence until proven guilty, and that's what paved the way for the two names to appear on the ballot. But most importantly is that the petition comes before the Supreme Court barely days before key contenders begin presenting their papers to the IEBC. And this is going to be interesting to see just how this pans out from the courts. Linda.
That's going to be very interesting, like you put it, because I remember a couple of weeks ago I was having this conversation with Danstan Omari, and he said it will be very difficult to bar people from contesting in the upcoming general election based on mere allegations. Someone has to be convicted. How is this going to play out?
Well, a few weeks ago, Betty, there was an altercation within the Jubilee Party over reports that some governors would be locked out from the party primaries on the basis of pending audit queries in the counties. Now, what happened after that was that the office of the Attorney General set up a caucus, including even the EACC, the office of the AG, as well as the key investigative agencies, including the Directorate of Public Prosecution, to look into the history of candidates that will be contesting in this election, just to see if there are some skeletons in the closet, and that would, of course, have occasioned their being locked out. Now, that particular move by the AG occasioned the petition of a separate case that has been taken before the High Court by activist Okia Omutata, and today he was here before the Supreme Court objecting the present case here on the basis that the High Court has not disposed of that particular matter, and therefore it would be improper, according to him, for the Supreme Court to proceed with the present case by the Human Rights Commission when the same matter is pending before the High Court. But of course, most importantly, Betty, remember, key contenders have already clinched the tickets of their respective political parties. Some of those that lost and feel aggrieved have gone to the disputes tribunals, while while others have chosen to go independent. And that momentum, in a way, tells you that very few of them will be willing to let go, even if that means them filing separate cases before court in less than 80 days to the August elections. Linda.
First of all, Murimi, this is Linda. I know you're used to speaking to Betty every morning. We'll probably have her back in, what, about a week or so. But then, Murimi, this brings the issue of IEBC timelines onto the table again, because assuming we get to a point where the courts decide there are some aspirants who do not pass the integrity test, IEBC timelines are still on course. Where does that leave some of these aspirants and the areas probably they hope to represent?
Well, if I got your question right, Linda, well, the IEBC has in the past indicated that much as they are strained with so much to do in terms of preparations for the elections, that they are well in course. But the judiciary as an institution has consistently and increasingly been one of the key institutions that have been on that political discourse with regard to IEBC's preparations. This is a case in which the IEBC is a party, and as well as very many other cases before the courts, including one filed last week by the opposition of IEBC's recent reshuffle of constituency returning officers. But that discourse has been ongoing for some time, including at one point where the IEBC was forced to cancel the tender for the printing of ballot papers. But what the electoral body has insisted is that they will do what they have to do to ensure that they are set for the August elections. But of course, it will be interesting to see just what pans out from the courts. The Chief Justice David Maraga has been on record to say that the courts will do their part, and that the ongoing altercations, the attacks on the IEBC and the courts are unwarranted, because anybody is welcome to come to court to petition any move by the electoral body which they feel is inconsistent with the constitution and the electoral laws in Kenya. Linda.
Listen, so we know that KNCHR has gone to court there at the Supreme Court, but then we also know about that group that you're talking about, the Chapter 6 Working Group on Election Preparedness. But then someone looking at this particular case, there seems to be a clash, because you have this group that's supposed to work and look into the conduct of different aspirants, and then you have KNHCR trying to go to court and get a representation. Where then does that leave the role of a Chapter 6 Working Group?
Well, Linda, that is the basis of the High Court case filed by activist Omutata, because what he argues is that the office of the Attorney General is a government institution. It's based within precincts of the government. Same case to the Ethics and Anti-Corruption Commission, much as it in a way is portrayed to be independent. And his argument is that that particular caucus cannot be entrusted the task of grilling candidates that will be contesting due to vested interests. I mentioned that particular case to you within the Jubilee Party, where there was a presumption among some governors that there was a deliberate attempt to lock them out from the August elections, apparently on the basis of differences within the party. But the basis upon which there were those reports were the pending audit queries that have been raised by the Auditor General, as well as the Senate Public Accounts Committee. And of course, it will be interesting to see what pans out in Omutata's case before the High Court, because that, in a way, will have an impact on the petition that has been filed here before the Supreme Court. Remember, when the Supreme Court resumes on the 21st for the mention of that particular case, one of the directions that will be expected from that 5-judge bench chaired by Chief Justice David Maraga is whether they can continue to entertain the petition that has been filed here, while some of the merits that are under argument here before the Supreme Court are still pending before that case at the High Court. Linda.
Thank you for speaking to us. Let's see how this pans out, of course, now.